Welcome back to US Updates Hub. If you or anybody dear to you has been waiting and waiting for an opportunity to push ahead on a green card application, then what I am about to present to you over the next few minutes could be the most consequential update you have encountered in a very long while. Because right now, in April of 2026, there are four separate groups of immigrants who hold a real, legitimate, and time-sensitive chance to apply for their green card. Some of these openings are extraordinarily uncommon. One of them has not surfaced in years, and here's the reality. These openings do not remain accessible forever. Visa Bulletin dates can shift backward just as swiftly as they shift forward. So, whether you are a green card holder yourself questioning if you can finally reunite with your spouse in the United States, or you are a worker who has been trapped in the employment-based waiting line for years, or you are a young immigrant who has been standing on the margins, remain with me because today's briefing is meant for you. Before we explore the four groups, let me briefly outline the framework we are dealing with, because grasping it makes everything else fall into place. Every single month, the U.S. Department of State publishes what is known as the Visa Bulletin. Consider it the government's official tracking board for green card availability. It informs applicants all across the nation and the globe whether their category is accessible for submission. The Visa Bulletin serves as the government's authoritative reference for immigrant visa availability, establishing the schedule for both family-sponsored and employment-based applicants. It covers individuals pursuing permanent residence through U.S. consulates overseas, as well as applicants already within the United States adjusting their status. Now, the Visa Bulletin contains two essential charts, and this difference carries enormous significance. The first is called the Final Action Dates chart. This is the chart that reveals when your green card can actually be granted and delivered. The second chart is called the Dates for Filing chart. This one functions slightly differently. It reveals when you can turn in your application documents, even if the final grant needs to wait a bit longer. For April 2026, USCIS has verified that applicants in all family-sponsored preference categories and all employment-based preference categories must reference the Dates for Filing chart. That is an extremely important directive, and it directly impacts all four groups we are going to examine today. So why does referencing the Dates for Filing chart carry such weight? Because turning in your application early, even before the final visa number is technically accessible, provides you something tremendously valuable. It secures your position in the queue. And for those of you within the United States, it also activates your eligibility to request work authorization and travel permission while you wait. That is the contrast between remaining at home uncertain about your destiny and actually working lawfully with a pending case. That is real, concrete relief. And right now, for four particular groups of individuals, that chance is fully available. Let us discuss the first group, and this one is arguably the most thrilling development in this entire bulletin. The F2A category, which encompasses spouses and unmarried children below 21 of lawful permanent residence, reveals the most noteworthy update this month. It has turned current across all nations, permitting applicants to submit without hesitation. Let me repeat that plainly because it is significant. If you are a green card holder, a lawful permanent resident, and your spouse or your child below the age of 21 is waiting to reunite with you here in the United States, the F2A category is designated as current in the Dates for Filing chart for April 2026. That means there is no priority date threshold blocking your path right now. You can submit. This uncommon and eagerly awaited advancement means that qualifying spouses and children who are physically present in the United States can promptly submit their Form I-485, application to register permanent residence, or adjust status, regardless of their priority date. Now, I want to be precise about the qualification criteria here, because not everybody in the F2A category will automatically be eligible to submit right now. To capitalize on this current filing date, the beneficiary must be physically present in the U.S., must generally maintain a valid non-immigrant status at the moment of submission, and must have either an already approved Form Y-130, a pending Form I-130, or be prepared to submit Form I-130 simultaneously with the I-485. And here's the practical advantage that is frequently overlooked. By submitting simultaneously, your spouse can promptly request a work permit and travel document while awaiting the final action date to advance so the actual green card can be granted. That is life-altering for families. Instead of being excluded from the labor market, your spouse can begin working lawfully. Instead of being hesitant to travel, your family member can secure advance parole. All of that becomes reachable the instant you submit. Now, I want to highlight something the immigration lawyers and specialists are declaring emphatically right now: do not delay on this. On the F2A category ordinarily carries waiting periods of months to multiple years. A current designation is uncommon and precious. Families who let this opening pass may encounter another extended wait before dates progress again. The Visa Bulletin dates can and do reverse direction, what immigration professionals term retrogression, sometimes with barely any advance notice. So if you belong to the F2A category, speak to a qualified immigration lawyer this week. Do not presume this will still be accessible in May. Now let us proceed to the second group, workers in the employment-based second preference category, identified as EB2. This development is groundbreaking. In the April 2026 Visa Bulletin, for the first time in years, priority dates in certain EB2 and EB3 categories are now current, signifying that there is no processing line or additional waiting period to become eligible to receive immigrant visas overseas or to adjust status to permanent residence in the United States. Let me translate that into everyday language. If you are a foreign national worker in the EB2 category, which typically encompasses professionals holding advanced degrees or individuals possessing exceptional ability, and you are not from India or China, your priority date is now current under the final action dates chart. That means you may qualify to apply for your green card right now, not in 2 years, not after another waiting period resolves. Now, EB2 final action dates have turned current for all nations except China and India. This represents a major achievement. Applicants in most regions of the world with an approved EB2 petition can now proceed to obtain their green card without delay. For those from India or China, dates have still been progressing substantially. India EB2 has maintained its forward trajectory, advancing by several months. So even if you originate from one of the higher demand nations, this is still a moment to stay attentive. Verify your priority date against the most recent bulletin and measure it against where you currently stand. Why is this occurring? Because visa approval rates at consular offices have decelerated, unused visa numbers have cycled back into the employment-based allocation, which has pushed priority dates forward. This pattern means applicants who are physically present in the United States and qualified to submit for adjustment of status may possess a distinctive window of opportunity right now. In other words, a combination of administrative conditions has produced a rare gap, and those who are prepared to move can gain substantially. If you possess an approved I-140 petition and your country of birth is not India or China, consult with your immigration lawyer immediately about whether you qualify to submit your I-485 this month. The third group is employment-based third preference applicants, or EB3. This category encompasses skilled workers, professionals, and other workers, including nurses, teachers, engineers, and numerous others. And the developments here are also remarkably favorable. EB3 professional and skilled workers dates have progressed considerably. The dates for filing for EB3 are now current for all nations except India, China, and the Philippines. So, if you are a skilled worker or professional from most regions of the world, say from Nigeria, from Colombia, from South Korea, from Ukraine, and you have been waiting years in the EB3 line, this is your moment to spring into action. Now, for those from India specifically, there is still meaningful advancement to recognize. India EB3 has progressed by approximately 5 months, now reaching January 15, 2015 for final action dates. While that is still a lengthy journey ahead for Indian-born applicants, given the historic waiting period, forward advancement matters. It means cases that have been stationary are now gradually moving closer to completion. And for workers in nations other than India, China, or the Philippines, the chance is immediate. For employers out there who sponsor foreign national workers, this is also a vital message because the popular EB2 and EB3 categories cover a broad spectrum of sponsored occupations, from software developers to teachers to engineers to registered nurses. U.S. employers are encouraged to continue sponsoring foreign nationals and maintain confidence in the process. Because sometimes there will not be a processing line at all. This month's bulletin stands as evidence of precisely that. Now, let us address the fourth group, and this one is especially meaningful to us because it involves some of the most vulnerable young immigrants in our nation. We are referring to Special Immigrant Juvenile Status applicants, commonly known as SIJS. These are young individuals, often teenagers or young adults, who arrived in the United States fleeing abuse, neglect, or abandonment, and who obtained a special determination from a state court acknowledging that returning to their native country would not serve their best interests. For Special Immigrant Juvenile Status applicants under EB-4, the priority date moved forward considerably this month, allowing many young immigrants who were trapped in the waiting line to finally advance with their green card applications. For these young individuals, the urgency is absolutely real, and it extends beyond mere immigration documentation. There are often aging out risks. When a young person reaches 21, they may lose qualification for certain types of relief. So, if you know a young person who holds an approved Form I-360 under the SIJS category, and they have been waiting in the EB-4 line, now is the time to thoroughly compare their priority date against the April 2026 Visa Bulletin and speak with an immigration lawyer without delay. EB-4 dates can and do retrogress without warning, so do not hold out for May. Let me now guide you through the practical measures that all four of these groups should pursue right now. Because realizing your opportunity exists represents only half the challenge. You must follow through on it properly. Step 1. Retrieve your immigration documents and locate your priority date. Your priority date is generally the date that your immigrant petition, whether that is a Form Y-130 for family cases or a Form I-140 for employment cases, was submitted to USCIS. It should appear on your approval notice or your receipt notice. If you cannot find that document, reach out to whoever assisted you in filing, whether that is an employer, a lawyer, or a family member. You require that date. Step 2. Navigate to the official U.S. Department of State website at travel.state.gov and find the April 2026 Visa Bulletin. Identify your category and your country of birth. Not your country of citizenship, your country of birth. Measure your priority date against the cutoff date displayed in the Dates for Filing chart. Remember, USCIS has verified that the Dates for Filing chart is the appropriate chart to reference for all categories in April 2026. Step 3. If your priority date falls before the cutoff displayed, or if your category is designated as current with a C, reach out to a qualified immigration lawyer at the earliest opportunity. Do not attempt to navigate the I-485 adjustment of status process by yourself, especially in a complicated filing landscape. A qualified lawyer can examine your complete immigration history, spot any potential concerns, and assist you in assembling the most compelling possible application package. Step 4. Compile your documents. Regardless of whether you submit this month or in the upcoming weeks, begin pulling together the materials you will probably need. That includes your passport, birth certificate, any previous immigration approval notices, evidence of your family relationship if you belong to the F2A category, evidence of your employer sponsorship if you belong to an employment-based category, medical examination results from a USCIS designated civil surgeon, and your affidavit of support documents. Getting prepared now conserves your time and reduces pressure later. And step 5, check back with us. The May 2026 Visa Bulletin will be published by the State Department in the forthcoming weeks, and there is always the prospect of movement, forward or backward. Immigration lawyers and commentators suggest applicants should anticipate measured movement following the progress witnessed in April. Historically, the government moderates or levels off priority date advances mid-spring, as it evaluates visa demand for the balance of the fiscal year, raising the prospect that some categories could remain steady or experience limited forward movement. We will deliver that update the instant it arrives. Let me leave you with this thought. The U.S. immigration system is intricate, and it can feel daunting, especially when you have been waiting for years and observing bulletins arrive and depart without any advancement in your direction. But right now, in April 2026, something truly remarkable is taking place. Four groups of immigrants, spouses, and young children of green card holders, EB2 workers outside India and China, EB3 skilled workers outside India, China, and the Philippines, and special immigrant juvenile status applicants all possess a real documented chance to advance forward. This is not guesswork. This is grounded directly in the April 2026 Visa Bulletin, published by the U.S. Department of State, and the filing directives verified by U.S. Citizenship and Immigration Services. Both of those official resources are publicly accessible, and I encourage you to confirm everything we have explored today at travel.state.gov and uscis.gov. A brief disclaimer before I release you. Immigration policy can shift, sometimes rapidly, sometimes without much forewarning. Retrogression is always a possibility. The information in this video is current as of April 11, 2026, and mirrors official guidance from the State Department and USCIS at the time of production. Nothing in this video should be construed as legal advice for your particular situation. Every immigration case is unique, and factors that are not apparent in a general briefing like this one, prior immigration violations, unlawful presence, criminal history, modifications in status, can all influence your eligibility. Please seek guidance from a qualified immigration lawyer or accredited representative before submitting anything. The stakes are too significant to proceed alone. If this video assisted you, please take a second to give it a like and forward it to someone who might belong to one of these four groups. You might genuinely transform someone's life by forwarding this update today. Subscribe to US Updates Hub so you never miss a monthly Visa Bulletin analysis or a breaking immigration development. We are here at every juncture to deliver clear, truthful, dependable information, because you deserve to comprehend the system that determines your future. Until next time, stay knowledgeable, stay patient, and take care of yourselves and your loved ones. This is US Updates Hub. We will see you in the next video. This content is for educational and informational purposes only. It does not constitute legal advice.